section 72.052 under the.
This is the new tort reform thing that just came out in the last sessions. Is that right?
That's correct, Your Honor. The tort reform legislation having to do with litigation against essentially trucking companies. Your Honor, we filed this motion. The plaintiffs filed a lawsuit, has to do with an accident that involves my client's tractor trailer, commercial vehicle. They filed suit against the driver and his employer. We filed this motion to bifurcate. Essentially, we're running up on the deadline. Deadline is 120 days after the defendant files the answer. The one thing I will say about this motion is that plaintiff's lawsuit, the petition, they at this time, the only allegations they have are for negligence against the driver and as to the employer, respondeat superior or vicarious liability claims. So admittedly, their claims fall within what would be in the first half of the bifurcated trial anyway, but we felt it was incumbent on us to go ahead and file this motion to bifurcate just in case any claims do get amended or added later on down the road. But as far as the substance of the new CPRC legislation, the new statutory guidelines, or what applies here, it's basically a mandatory thing as we read the law. If the defendant moves to bifurcate, the case is bifurcated. And essentially what the scope of the first trial is just on plaintiff proving that there is negligence on the part of the driver. And that would, of course, lead to entitlement to be able to bring an action at that point against the employer for direct negligence claims and possibly gross negligence claims. So that's the lay of the land, but that is our motion. And so we move to bifurcate. And of course,
right. Mr. Valencia, do you have a response? Mr. Valencia, do you have a response?
Yeah, sorry. I was just, again, counsel kind of mentioned the issue with the fact that we haven't alleged any of the exemplary damages portions as the statute addresses. And so as a result, we think that this issue is moot. I understand I guess there was deadlines associated with the claim, and I wouldn't be opposed to considering addressing the potential bifurcation if we are through discovery to determine that there may be gross negligence at play. And so I'm okay, considering the bifurcation issue.
So if I understand it, Mr. Reed, that he hasn't actually made any of the claims that would need to be bifurcated at this point?
Yes, Your Honor, that's essentially correct. The allegations in the petition are simply for negligence against our employee driver, the usual negligent claims against the driver involved in a motor vehicle accident, failure to maintain a proper lookout, failure to apply brakes properly, failure to maintain control, failure to turn the vehicle, basically an evasive maneuver, in traveling at an unsafe speed, and failing to maintain adequate distance. So as Your Honor well knows, normally the plaintiff's petition will also.
Can you share screen the provision that you're relying on for the bifurcation, just so I can read the exact language of it?
Yes, Your Honor. Just give me a moment.
This is the first time this has come up, so I figured it'll come up more often, but this is a pretty new provision.
That warms my heart, Your Honor. So for now and forever, I will always be the first one in court to have brought this act, brought this.
Who knows, he might be the only one, you never know, so.
Well, then that would be a dubious honor at that point.
I thought we'd have so many, issues involving that expedited trial rule that came out a few years ago, and we had almost nothing on it. You just never know how these things are going to play out. But then the TLRA or TLR, sorry, the CPR, well, I'm sorry, forget it. Let me just read this.
Judge, if I could, actually, I want to interrupt you reading it. Okay.
So it says you have 30 days, that's what I thought, after the claimant files a pleading adding a claim against the defendant bringing the motion. So you have 30 days after if he amends this, right?
Yes, Your Honor. Again, correct. As I said at the beginning, though, basically this is kind of an out of an abundance of caution kind of deal that we went ahead and filed this motion.
Yeah, I think I tend to agree with the plaintiff. I think it's premature. I think you're probably right. It's going to be yeah. I mean, I don't necessarily think that this provision was needed, but it is what the law is. And but I think it's premature since he hasn't made any of those claims. If they make those claims, then you have 30 days to bring in the motion. So that for now, if you could prepare me an order that just says this is denied without prejudice. Okay.
Yes, Your Honor. Happy to do so. I will submit that to, I'll prepare it, circulate it to counsel, and then I will submit it to you.
One other thing I'm doing on these now is if you could say at the beginning that this was heard on May 9th, 2022, as opposed to on this day, and then email it to Rhonda as well as Yvonne. Okay.
Will do, Your Honor.